Imagine this. You've been charged with sexual assault, and you and your lawyer have been working on the case for 2 years, and it's now set for trial. And you're stressed beyond belief. Your lawyer spent a few hundred hours over those 2 years preparing. You've spent untold hours. All your defense witnesses are ready to go. The Crown's ready to go. You show up on the day of jury selection, and the Crown withdraws the case. And you say to yourself, how on earth did it take 2 years for them to figure out that there's no reasonable prospect of conviction, or it's not the public interest? So it's a great question. This is the Kruse Law YouTube channel, and we answer common FAQ type legal questions that people ask out there. And this is, why does it take so long? Why does it take sometimes years before a charge is withdrawn? And that's a great question, and I'm going to answer that. I'm going to give you some examples, and it breaks down to many different areas in this regard. And I guess first and foremost, one that crops up is witness problems. What happens in a lot of cases is maybe the complainant gets cold feet, the alleged victim changes their story, their memory's all of a sudden not so good, and the Crown realizes that late in the day and it gets withdrawn. Or maybe they don't even show up at trial. Maybe they can't be located. So those are some evidentiary issues, basically. Well, a key issue, the witness can't testify, so there's not much of a case if it's a one key complainant that you're depending on. The Crown's got no further case. There's other issues. Sometimes evidentiary issues crop up late in the day, and one is the alleged victim recants their version of events on a sexual assault trial, or new evidence arises just before the case, for example, that convinces the Crown that there's no longer a reasonable prospect of conviction and it's not in the public interest. That's the test, by the way. The Crown, throughout the course of a prosecution, has to ask themselves, is there a reasonable prospect of conviction in this case, number one? And number two, is it in the public interest that I proceed with this prosecution? And oftentimes they come up with the answer no, and it's on the courtroom steps. So evidentiary issues emerge. Maybe the defense challenged certain evidence and won a pretrial application just before the case that evidence didn't get in, and the Crown says, oh God, without that evidence, I don't stand much of a chance of winning. The complainant wants to just do a peace bond here and will withdraw. Maybe the complainant just changes their mind, as I said, and recants their story. And then, of course, there's charter litigation. So your lawyer may have been told the Crown, look, we've got a great charter argument. We're going to bring it. And the Crown says, bring it. I don't agree with you. And then 60 days before the trial, your defense counsel, that's, they're filed just before the trial often, brings the charter application. Finally, the Crown studies this and goes, oh my God, this is a great charter application. The case is can't win the case. It's excluding the gun from evidence. It's excluding the drugs. Comes to grip with it in the last seconds and withdraw it. Happens all the time, unfortunately. There's another reason. Another reason is our delays in the province. I mean, sometimes, especially in busy counties, we stack a lot of trials, particularly in the Ontario Court of Justice. They'll schedule a few different trial matters. And on a particular day, if we've got an impaired driving trial scheduled that day, the Crown does, you've got a sexual assault and you've got an aggravated assault, you've got to decide which one's going to proceed. And if you're beyond the delay, criteria, which in Ontario Court of Justice is 18 months and Superior Court is 30, the Crown might decide to withdraw it. Look, there's a valid delay application here and it's going to get withdrawn. The Crown defense has brought a delay application, or the Crown says, look, I'm going to be sunk on the delay application. So that's called trial stacking, which leads to problems, which leads to delay problems, and the Crown's got to decide on what to proceed. They can put the case over, but if they know it's a delay, they might not do that. So there's another reason that things happen. So there's all sorts of reasons for this. That's systemic resource problem, okay? And, I say this a bit tongue-in-cheek, but you can't imagine how many cases I've been involved in where I've met with the Crown many occasions. I've done tons of work on the case. I've had a judicial pretrial with judges. I'm telling them that the case is weak. They don't agree with me. And the Crown, the Crowns are busy and they're not looking at a case in depth. Like when I have a sexual assault case or good defense counsel, you're looking at it for hours and hours and hours. You know that case inside and out. The Crown might show up at a judicial pretrial and look at the case for an hour. Oh, we got a strong case. Well, they haven't reviewed the transcripts, the video, this. And it's a little bit, I say this tongue in cheek, it's a little bit like writing university exams. You remember when you were in school and you studied at the last second? Well, sometimes the Crown studies at the last second and realizes, oh my God, I've been telling the Crown, the defense, I have a strong case for 2 years. Night before the trial, I've got no case. Look how bad this witness is. I've got no reasonable prospect of conviction. Yeah, I told you that 2 years ago. Well, that's human nature, is it not, to deal with problems until it's staring you in the face? And that happens a lot too. So there's all sorts of reasons. There's evidentiary reasons, witnesses not showing up, delay, perhaps Crown not dealing with their case, charter applications that convince the Crown. And now we have someone who's gone through stress for 2 years only to get withdrawn at the courthouse steps or maybe get a peace bond. Does it go on? It goes on all the time in our province, unfortunately. And it's a little bit of it is people, not a ton of it, but a small portion of it is some prosecutors actually not coming to grips with their case early on when they should, finally realizing that I don't have any reasonable prospect of conviction, or there's no prospect of, it's not in the public interest to proceed. But there's other issues that arise too, which I told you about, which the Crown could control, which happen the last second all the time. Witnesses not showing up, complainants getting cold feet, changing their story, you name it. This happens all the time too. But a small part of the problem, and I hate to say it, is just people not coming to grip with their case to the last second. And it happens, and that's human nature, isn't it? So there you have it. We went over the various reasons why cases are withdrawn at the last second. I guess the takeaway from this is, if you're a person in this situation, my God, you're going to ask yourself, why did this take so long? But you're probably going to be pretty fortunate, pretty happy that it does happen, though, aren't you? So there you have it. That's the video of the day. I hope you enjoyed this video, and I look forward to seeing you in the next video. And if you enjoyed this video, please like it and subscribe to our YouTube channel. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.